welcome to Legally Speaking with me, Tarun Nangia. The Supreme Court passed a pro-arbitration judgment, namely a bench of judges comprising of Justice Dhananjay Chandrachud, the Chief Justice of India, Justice Sanjay Kishan Kaul, Justice Sanjeev Khanna, Justice Bhushan Gawai, Justice Surya Kant, Justice J.V. Pardiwala, and Justice Manoj Mishra. This is a 7-judge bench which held that inadequately stamped agreements were enforceable. And in a sense, in the case of arbitration, this is a pro-arbitration move. And this is why we discussed this judgment, where India is now being increasingly seen as a pro-arbitration destination. This judgment is a series of judgments which, in a sense, instills confidence in the business community to arbitrate in India. But we have someone who are experts in the field, who know this much better than I do, and they will share more insights on this judgment and what other things need to be done to make India a pro-arbitration destination. I have with me Senior Advocate Sanjay Jain. Sir has served as the Additional Solicitor General of India. Now he's a Senior Advocate practicing at the Supreme Court of India and other forums. Good to see you, Mr. Jain, and looking forward to some interesting insights from you. I have with me Kunal Vajani. Mr. Vajani is a joint managing partner of law firm Fox and Mandal. He is also court member for India at the International Court of Arbitration. He joins us on Legally Speaking for the first time. Welcome on Legally Speaking, Mr. Vajani, and looking forward to your insights. I have with me Manmeet Singh, advocate. He's partner with Saraf & Partners, one of India's leading law firms. He is heading the dispute resolution practice at the firm. And I'm happy I have a very interesting panel, one senior counsel who argues in the courts, 2 law firms who routinely do a lot of client-facing to get matters and the challenges that they face on arbitration. We will get to know challenges from the law firm's end, challenges from the counsel's end, and that promises to be an interesting discussion. At the outset, let me request Mr. Sanjay Jain to give an initial comment, and then we move forward. Over to you, Mr. Jain.
See, in my view, this judgment reaffirms the earlier view which was prevalent, but there were some gray areas, and on account of certain judgments which were passed in between, there was a fair bit of confusion as to whether the unstamped or inadequately stamped arbitration agreement can be commented upon by Section 8 or Section 11 court in the event a situation arises where an agreement has to be brought to Section 8 or Section 11 court for the purposes of initiating the arbitration proceedings. Now, there was always another situation where the parties had agreed to an arbitral tribunal and the matter would have gone directly to the tribunal. In whichever eventuality, it was always open to another party to say that this arbitration agreement is inadequately stamped or is unstamped, and therefore it is inadmissible in evidence. And because the underlying contract is the basis for the claim or counterclaim, so it should be taken as indivisible. And all those arguments were possible. Now, the 7-judge bench has put to rest all those possibilities of arguments. It has very categorically stated that the arbitration agreement is severable from the underlying agreement, and the arbitration agreement, even if it is assumed as unstamped or inadequately stamped, is here to stay. It can kick-start an arbitration, and Section 11 or Section 8 court need not go into this aspect. And on the broad principles of competence, the arbitral tribunal can decide the issue, and this is how it lays bare a complete, clear roadmap for the arbitrations to be initiated without any hiccup or delay, and leaves it open to the arbitral tribunal to decide the question of inadequacy or insufficiency or non-stamping of the arbitral agreement. So this is how it brings a complete change. I would not say complete change, but a significant change in the gray area, which hitherto had plagued many an arbitration.
So you're happy that the judgment, in a sense, rendered by the 5-judge bench has been revised now. This is something that you're happy about.
Yes, I believe that even a five-judge judgment was not as as ambiguous as it was made to be. It was fairly clear, and the same result could have been achieved by perhaps a review. But it is always better that a larger bench clarifies the whole situation. And what better bench we could have than the present bench, that the senior most judges grouped together, and they clarified this ambiguity, whatever extent it prevailed.
Okay, point well taken. I'll take this to Manmeet Singh, partner, dispute resolution practice at Saraf and Partners.
So the court has relied upon the fact that understamped document or non-stamped document is essentially a curable defect, and that's been the position in law. Now, given that that's the position in law, a distinction has been drawn between a document which is void and one which is inadmissible. And the court has said that for something which is curable, it should be sent to the arbitrator for the arbitrator to decide as to whether it is actually understamped or not, because that by itself becomes an issue. Now, Tarun, you're aware that over the years, there have been several amendments to the Arbitration Act, and some which have been very express in their intent. For instance, the time period for completion of pleadings has been limited to 12 months. Now, what good is that 12 months if the process of initiation itself is going to take years on the basis of this issue of whether an agreement is understamped or not? And therefore, this decision is a pro-arbitration decision. It lays down the path very clearly that the matter will be sent to the arbitrator. The Arbitration Act has always been very clear that the court will not intervene except where provided. However, there has been a trend from time to time, that trend emerges. And I'm very glad that Supreme Court has decided against that, decisively decided against that trend this time, that while the points of intervention are well defined in the Arbitration Act, particularly Part 1 of the Arbitration Act, but within that, the courts have from time to time sought to expand the extent of their intervention and involvement. So, for instance, in Section 11, this should never have been the position, but now, thankfully, the Supreme Court has clarified the path forward, and it will certainly help in making India emerge as a pro-arbitration destination.
Point well taken. I will take this to Kunal Rajani, Joint Managing Partner, Fox and Bundle, also represents the ICC in India. Good to see you, Kunal. Your comment on this issue.
I think, Tarun, it's a very historic moment in the entire arbitration ecosystem, particularly because what began early this year or the end of last year and then reached into a 5-judge bench judgment in April sort of was cured in the fastest ever manner that we could see, to ensure that the intention of a special statute, which is the Arbitration Act, is brought to a sanctity of process. The other aspect that we see is the international doctrines, which have been salutarily recognized through the UNCITRAL model or the New York Convention, which our law also recognizes in different forms of sections, which is the party autonomy, the doctrine of separability, and, as Mr. Jain said, the doctrine of competence. All of that, the court has kept in mind to be the correct salutary principles, the correct intent behind the legislative drafting of the Arbitration Act. And then to take out the distinction to say that at the inception, like Manmeet said, at the inception, there has to be minimal judicial interference. At the stage of Section 8 and Section 11, when parties come to say that there is an arbitration clause, the only prima facie examination required is the intent to arbitrate, the actual existence of the arbitration clause, and all issues ancillary thereafter are left for the arbitrator to decide. So this actually completely emboldens the entire process, which was sort of put to a retrograde position, which there was a lot of confusion over this entire 1 year, which has now been set at naught at the quickest manner, and that also by a very historic strength of a bench, which is 7 judges.
Okay, thank you. Thank you so much for that input. I'll take this to Senior Advocate Sanjay Jain. Could you give me a larger input on how court has turned pro-arbitration during Justice Chandrachud's being at the helm? In your view, because we see that there is a certain proactiveness in promoting arbitration as a medium of dispute resolution in his tenure.
Certainly, Tarun. this aspect has can be very distinctly assessed and visualized from the fact that in the matters where the commercial interest of the country is involved, or the overall perspective or image of the country is involved, that India as a destination for investment is conducive to the arbitration ecosystem, it was very important to send a message across the world that here is a judicial system which encourages the arbitration to be conducted in an expeditious manner. That is one. Secondly, it encourages the interim applications to be adjudicated at the earliest in the fastest possible time, and in a very comprehensive manner with the proper application of mind, taking into account all nuances and subtleties and all other aspects which are peculiar to the ecosystem under which those contracts have been executed, and the industry practices and the peculiar aspects of those contracts which are well understood. And thirdly, the enforceability of the awards. On all these fronts, in the last 12 months, if we see, the Supreme Court has been very proactive, and under the I would say the leadership of the Chief Justice, and the way the overall atmosphere, even in the addresses which he has given at various forum, in educating the members of judiciary right up to the district judges level, this whole movement has gained momentum, and the judges are much more alive to the sensitivities of the arbitration proceedings, to the sensitivities of the interim applications which are placed before them for adjudication, and also in the disposal of Section 34 petitions, especially the understanding with regard to the patent illegality, contra-distinguished from other aspects on which 34 can be pressed into service, the limited scope of 37, and also the limited scope of 36. All these aspects have been galvanized and expressed in the form of various judgments by various courts, including Supreme Court. So this has set up a very different atmosphere and a roadmap to go ahead. And this can also lead to a situation where the international arbitration can also gain momentum in our country, with more and more centers coming forward and taking up the cause. So that is there, Tarun. Definitely, this aspect is discernible, clearly discernible.
Point well taken. I'll take this question to Manmeet Singh from Saraf & Partners. Manmeet, so clear push to arbitration during Chief Justice of India, Justice Chandrachud's tenure. Do you see a pattern that the court is, in a sense, making efforts?
No, absolutely, I agree with you. I think last week also we saw judgment in Cox and Kings, which also has clarified the way forward. Now, I think after PASL, it is well understood that two Indian parties can choose a foreign seat. Now, if we don't improve the arbitration environment in India, that will lead to a position where not just international commercial arbitration, which is already going to Singapore and other places, London, etc., we will also see big ticket arbitration between two domestic parties move to Singapore and London as a seat. So if we have to retain India's attractiveness as a destination for dispute resolution, we have to have a pro-arbitration regime. And I think there's certainly a concerted effort under the Chief Justice's tenure to ensure that we make progress in sync with the rest of the world when it comes to adopting the arbitration principles, which, as Kunal said, are well appreciated through ICC, Unstamped. So there's certainly a concerted effort. I think there is no reason why going forward in the next few years, India cannot emerge as a hub for arbitration. Not on par with maybe some of the international destinations that today we speak of. We need to make sure that court's intervention is minimal. We need to make sure that while, for instance, in High Court, we have a commercial bench which looks after certain kind of matters. There are dedicated courts with dedicated judges. Today, we don't have that. In High Court, for instance, the roster changes and all the knowledge building which happens for us lawyers. And with all humility, the new judges who may not have held the arbitration roster, who then come in, so that process also needs to be looked at. Should we, like Singapore, have a dedicated wing of the commercial court, look at some of these issues? So I think we need to take some more steps. The government has also set up an empowered committee to look at the next round of reforms which are required, including whether we need to have a statute for international arbitration. So certainly Supreme Court has been focused on this, and I think that also gives a direction to courts below as to how you have to approach arbitration.
Point very taken, direction to courts below also, how to have an approach also with arbitral awards. Enforcement also is an issue that sometimes crops up, but that is a discussion for another day. I'll take this to Kunal Vajani from Fox and Mandal for his comment.
So Tarun, I cannot but concur with my two learned senior friends that this is a very, very progressive move, and we see the court's mindset to be in a progressive move. Sometimes it's just a perception game that we see, but really I don't think, as far as the Arbitration Act is concerned, or creating a good ecosystem for an alternative dispute resolution in India is just a matter of a perception game. The court, I think, has been taking cognizance of all the problems that arise, all the gray areas, all the clouds of doubt that have been arising in the implementation of the Arbitration Act, and been with higher number of strength of judges, as Manmeet pointed out, Cox and Kings, or a 7-judge bench now, in the higher strength as well, taking up these issues expeditiously and resolving them, bringing about clarity. What the court in this judgment has also done is a complete harmonious construction of 3 very important statutes: the Indian Stamp Act, the Contract Act, and the Arbitration and Conciliation Act. Now, in that level of interpretation, which is really what the Supreme Court is meant for, that level of interpretation today will, I think, set the tone for the next 20 years on how this entire regime of arbitration is to progress. One aspect which even Manmeet touched upon and Mr. Jain touched upon is how the courts need to interfere, or what is the restraint the court needs to do. And one salutary provision which the Arbitration and Conciliation Act has is Section 5, completely non-talked about, completely non-looked at, but this judgment completely amplifies Section 5, which means the extent of judicial intervention. And the court says the extent of judicial intervention must be minimal. It also marries with the model law, Article 5, but that's something which is already there in our statute book. Our legislative intent is always meant to be that the extent of judicial intervention has to be minimal. And I think the judgment is the most progressive judgment that we can see for times to come.
Thanks, Mr. Vachani. I'll take this to Senior Advocate Sanjay Jain. Mr. Jain, if you have a wish list, things have been done well in the past 7-8 months. Courts, specifically mentioning the Delhi High Court, you see them not tinkering with the awards. Like there has been experience in some other courts where there is a tendency to do justice, where we try to think, if I may say, see things from the prism of socialism when the award numbers are big, if I may say so. What is a wish list that you would have for the future in what you can say arbitration as a service to the commercial investors in India, for them to see it as a destination? Any wish list that you have?
My wish list would start with the proper understanding of this 7 judges judgment in the first instance. Because what we need to understand is that suppose this objection with regard to the insufficiency of stamping or non-stamping is taken at the level of the arbitral tribunal, because this is what the mandate is. And then the tribunal comes to the conclusion that the claims, because claims or counterclaims are based on the underlying agreement. Underlying agreement is the same in most of the cases. So therefore, if the tribunal comes to the conclusion that the instrument needs to be impounded, and then it has to be referred for the adjudication by the stamp collector under Section 35 of the Stamp Act, that much time which will be consumed in the whole process will be the time consumed out of this 12 months which has been given to the tribunal under Section 29A. This is a very important aspect which we need to keep in mind. So ultimately, suppose the judgment would have been otherwise, that Section 8 or Section 11 court, if a matter is brought to them, would have decided this question, and then Section 8 or Section 11 court would have impounded the document and referred it to the stamp collector, then maybe that much time could have been saved and the tribunal could have started from the beginning straightway. But now the tribunal itself has to do this job. So therefore, the stakeholders have to act in a mature manner, so the arbitrators also, to ensure that the time is not lost and significant time is not lost in this process of having the inadequately stamped document adjudicated from the stamp collector, because that aspect has been kept open in the judgment, and rightly so, that insofar as the underlying agreement is concerned, which is severable, and there if the document requires stamping and it is not stamped, it may be inadmissible. And if the claim itself is based on that underlying document, then it will be impossible for a party to prove the claim. So therefore, that aspect needs to be taken with maturity and handled with maturity. This is my first in the wish list, that this judgment, the implication and the implementation of this judgment is not brought to naught by immature handling of it. This is one. The second aspect that I would like to have more clarity is with regard to the aspect of fraud, etc., which has been brought in the domain of Section 36. That till the matter is pending before Section 34 court, the ground of award being obtained by fraud, or the contract having been entered into with the fraud, all those grounds which have been brought by Section 36(3), there needs to be a greater amount of clarity in those matters, because it has been seen that the awards which are passed against the government comes at a later stage after 34 is decided, and says that we have now come to know that there was a fraud played upon at the very inception, and then a lot of time is consumed in this process. So there are certain gray areas which emerge from the objections, the kind of objections which are being taken in Section 34 courts or Section 37 courts. So there is a need to be addressing those questions, and those questions need to be assimilated and brought to the notice of the lawmakers, and there has to be a constant review of the kind of objections which are being taken against the awards, and so that there is a correction mechanism, self-correction mechanism, which is constantly in process. Only then we can make our system robust. Otherwise, if we suppose we are happy that all right, we have incorporated Section 34 with particular kind of a regime, there are n number of judgments which have interpreted 34 in a particular manner, and that is the end of it. So it is not correct, because it is a dynamic process and we constantly need to evolve. So therefore, when we say evolve, not only the evolution is necessary, not only at the level of the judgments by the court, but also by consistent amendments in the Arbitration Act, so that all those irregularities, all those difficulties can be corrected in a proper course correction.
Thank you for the wish list and the inputs you gave. I take this to Manmeet Singh from Sarafan Partners. First of all, whenever a foreign company is in JV talks with an Indian company, many times we see that they insist that the seat of arbitration is in Singapore or some other place other than India. Keeping even these attitudes in mind, foreign companies' reluctance to have India as a seat of arbitration, what's your wish list from the courts and the larger ecosystem?
So, Tarun, when foreign investors insist on London, Singapore, other places, it could be on two accounts. One is purely the need to have a neutral jurisdiction. I think that is something we would not be able to solve for, because very often in cross-border agreements, parties prefer having a neutral jurisdiction, and therefore they would not agree to India. The other thing which we can solve for and we must solve for is that we are seen as a jurisdiction where delays are endemic. And I think that is something we can certainly solve for. So barring an issue where a party seeks to have a third jurisdiction, such as Singapore and London, for reasons of neutrality, because as I said, that is an important ask at for certain investors. But barring that one case, we must work backwards to address India and make India as a hub for international arbitration, and not just preventing domestic arbitration from moving to Singapore as a seat, because that's also possible now, and not just preventing certain arbitrations where there is a foreign investor who would otherwise be willing to have India as a seat, or Delhi, Mumbai, Hyderabad as a seat, but for the fact that India is seen as a place where delays are endemic in the system. But there is nothing which stops us from becoming a neutral venue for two foreign parties, much like Singapore. I think we have the human capital, we have the infrastructure. Now, if we can solve for some of the issues which are very solvable, I would say, then we can attract a lot of business, dispute resolution business. And it has a multiplier effect. It's not just the legal fee, it is what the hotels would make, it is what the arbitration centers would make, it is what the airline companies would make. And it's very interesting that if you look at the terms of reference for the UK Law Commission, which was set up to review their 96 Act, it expressly recognizes the contribution of arbitration services and allied services to UK economy. And they recognize that they are in excess of a couple of £1 billion, and they go on to say the indirect impact is probably larger. So we have to look at arbitration as a services sector contributing to the larger economy. Now, it may not be as big as IT and would never get there, but it will certainly add to the pool of economic activity in the country.
Okay. Point well taken. I'll go to Mr. Kunal Vajani for his intervention.
So, more to add to this would be a position that one very important part of the wish list now would be that whilst the courts have given their entire verdict on Section 8 and 11 and the restraint to be maintained at the stage of Section 8 and 11, the same intent has to be imported when the court deals with a Section 9 petition, which is for interim reliefs, because more so Section 9 will jump into courts much before an 8 and 11 would go to court, because somebody needs an interim relief emergent. So this very judicial restraint that the court at the stage of Section 9 does not embark on a journey of inquiry of the adequacy of the stamp duty and says, yes, there is prima facie, I see an arbitration clause and the interim reliefs are to be granted. There is a small passage in the judgment which Justice Chandrachud has written, but there is no real further elucidation on Section 9 because the court does not touch or deal with Section 9, because the court says NN Global 2 did not deal with Section 9. But however, I think this intention that the court has brought out in the entire judgment and the true spirit of the judgment can only be implemented if the same restraint is maintained whilst dealing with Section 9, that you progress to grant interim relief or decline the interim relief on its own merits without being marred by any sort of illusion on the stamp duty having paid or not paid, adequacy or inadequacy thereof. That's a big important milestone that we will have to see achieving in times to come, because this judgment does not deal with Section 9 at the moment.
Thank you for all the inputs that my panelists shared with me today. Will be useful, because we're soon going to do an enforcement series, because this is a request. When we speak to many people, they will always say that enforcement remains an issue in India. The arbitration process is good, but when the time of enforcement comes, sometimes the way one thinks, say in court, when the numbers are too big, then there is this tendency to do justice, and then things the interest cost may sometimes then exceed what is the arbitral award finally worth. And that becomes the issue. But that's not the issue for today. Today was to celebrate a pro-arbitration judgment by a 7-judge bench of the Supreme Court, of which none other than Justice Chandrachud, the Chief Justice of India, was a part, and a very fine bench and a very fine pro-arbitration judgment. It is something that we should celebrate whenever our courts take a pro-arbitration stand and send a message to all the courts to do so. I appreciate that Senior Advocate Sanjay Jain, Manmeet Singh, Head of Dispute Resolution and partner with Saraf and Partners, Kunal Vajani, founder, managing partner with Fox and Bundle, joined us and shared their views. Thank you so very much. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.